Our next speaker is David Esquivel of Bassberry in Nashville, Tennessee. He is our anchor speaker, and he has been listed as a Tennessee super lawyer since 2013. David concentrates his practice on counseling, investigations, and litigation in the financial services sector, with emphasis on matters relating to the Fair Credit Reporting Act. Increased government investigations and enforcement actions, and an uptick in plaintiff class actions under the FCRA's generous remedial provisions are new realities. David offers us a primer on the Act and its litigation landscape. Please join me in welcoming him.
Let me start by acknowledging what I know has been on your minds ever since you received the agenda for this meeting, and that is to put a topic as controversial and sexy as credit reporting on the agenda and then make you wait all the way to the end to talk about it. Like me, I know that you are hearing about bribery in Nigeria and Heisman Trophy winners and murder trials and thinking, yes, but can we please just get to the credit reporting? So I'm here to tell you we finally reached that point and we can all breathe easier. I do want to talk to you about credit reporting and federal law that governs credit reporting. There are many of you who are in industries where this is a primary area of focus and you understand and can appreciate the private litigation and regulatory impact of these laws. But I think by the end of the presentation, I hope those who aren't immediately concerned with credit reporting and federal laws governing credit reporting will recognize that it touches many different aspects of business, and in fact, I venture to say everyone in this room is an employer. And as an employer, in many ways, you probably have some exposure or risk related to credit reporting, and we'll talk about that. So there are three things I really want to do in my presentation. The first is just to orient you to the federal law that governs credit reporting, the Fair Credit Reporting Act. The second thing is to take you very broadly through the principal entities that are regulated by the law and what the responsibilities, again, at a very general level, what the responsibilities are of those entities. And then the third is to give you a snapshot, an idea of what recent litigation, private litigation is in this area, and also a very increased stepped up presence of the government agencies, the federal agencies in particular, that have responsibility for enforcement and supervision and credit reporting, because they have been very active, and in this area, particularly now, an ounce of prevention is worth a pound of cure. So this is to orient you to what we're talking about. The Fair Credit Reporting Act, passed by Congress in 1970, relates only to consumer credit. So this is not an act where there are lots of sources and mechanisms for businesses who extend credit to one another to receive that information. The act doesn't govern that. This is strictly dealing with consumer credit. That means personal, household, and family expenses. There are two major things that are sought to be accomplished by this act initially, and then a third added later over time. The first is privacy. The credit bureaus, which are the prototypical entities that are governed by this act, the three major credit bureaus in the United States have enormous amounts of information about everyone in this country, and that information is used for important decisions on buying a car, buying a house, employment, many different things. And so that volume of information needs to be private, and much of the act goes to ensuring that information that is kept by many different sources remains private. And it's only shared with people and entities that are entitled to that information and for proper purposes. The second major goal of the act is accuracy, because so many important decisions are based on consumer credit information. The act imposes on all of the players in this system an obligation to make sure that the information is as accurate as possible. And then a third major component of the Act that has evolved over time is identity theft. There are now, through amendments to the Fair Credit Reporting Act, a number of provisions that make disclosure obligations for the various participants in consumer credit to address the problem of identity theft. Each year, the Federal Trade Commission polls consumers to find out what their most pressing problems are. And for many, many years, the number one problem consumers report is identity theft. And so the Fair Credit Reporting Act speaks to that through recent amendments. So that you understand, this is part of, the Fair Credit Reporting Act is part of a suite of consumer protection laws, federal consumer protection laws that broadly have similar purposes, and they broadly have similar enforcement and private remedy regimes. And they include debt collection, the Fair Debt Collection Practices Act, the Truth in Lending Act, and the Real Estate Settlement Procedures Act. There are I've identified four players in this system. One is Furnishers. These are any entity that provides information about consumers upon which credit decisions are made. Users, again, any entity that, in common language pulls a credit report in order to make credit decisions. Those two are frequently overlapping. Those who use credit reports also furnish information about the consumers they deal with. The consumer reporting agencies, again, when you think about this, you think about Equifax, Experian, TransUnion, those credit bureaus, but there are a number of entities that fall under the category of consumer reporting agencies. In a minute, I'll go through an example with you because the definition of that is quite broad. And the fourth, I put employers, is really a subset of users, but I've highlighted employers just because in the litigation landscape, there's been a lot of activity in the last 2 years, which can best be described as gotcha lawsuits under the FCRA against employers and their FCRA obligations. So I want to break those out separately for special attention. So who are furnishers? It's anyone who supplies information about consumers to a consumer reporting agency. These are primarily financial institutions, banks that issue credit cards and make reports about payments that consumers make on credit cards. They are loan servicers, mortgage companies that service mortgages, that service student loans. They can be retailers directly making these reports, healthcare providers, either directly or oftentimes through debt collection agencies. Right now, there's a lot of attention focused on the amount of medical debt that is listed on people's consumer reports and what can be done about it. So furnishers are anyone who provide that information. Users is anyone who gets a credit report and uses it to make a decision on credit, insurance, or for employment. What are generally speaking, the duties of this category of people under the FCRA? One is accuracy. As we said, the Act generally imposes an obligation for people who furnish information to make sure they're reporting accurate information. This is not a strict liability regime. The Act presupposes that with this amount of data that there are going to be mistakes. But what it does is imposes requirements on furnishers and on consumer reporting agencies to correct mistakes when they occur. So accuracy is achieved under the Act by mandating that furnishers of information have mechanisms to address disputes. Consumers become aware of inaccuracies in their report, and they can either directly or indirectly let furnishers know about them. Direct is sort of an obvious route, which is if I am servicing a student loan and the borrower receives a copy of his credit report and thinks that he or she has made all of his payments on time, but the report reflects otherwise, the borrower can call me, the student loan servicer, and say, you're reporting something inaccurate in the credit report, and I need you to investigate and fix it. That then triggers an obligation on the part of the furnisher to find out whether the borrower is correct And if the borrower is correct and there's an inaccuracy, then to notify all of the entities that the furnisher provides information to tell them about the inaccuracy. That can be done indirectly because there's also a mechanism for the consumer in that situation to tell the credit bureau, the consumer reporting agency, about an inaccuracy, and that CRA then has the obligation to notify the furnisher. There are different implications for private liability depending on which route those disputes are made. But broadly speaking, furnishers have to respond to these disputes. One thing that has developed more recently is that the Federal Trade Commission several years ago engaged in rulemaking and decided that in addition to the general requirement under the Act that furnishers have processes to investigate disputes, they also wanted, as a prophylactic measure, to have furnishers have written policies addressing them. So this is something to be aware of. It is not merely sufficient after this rulemaking to adequately address disputes. There have to be written policies and procedures in place, and there have been enforcement actions that are premised on the failure to have written policies and procedures separate and apart from the substantive conduct. So if you are a furnisher of information, this is something to be aware of. Duties on users are really the sort of the least, it's the least regulated aspect of this, and the general duty is not to pull a credit report without a permissible purpose. The Act doesn't have open-ended permissible purposes. The Act says here are a list of permissible reasons to get a credit report, and there are no others. Usually it's not a very difficult exercise to figure out whether there's a permissible purpose for what you want to use a credit report for, but sometimes there is. And the other general duty is if you are a user of a credit report and you make a decision based on the information you've gotten, say you deny someone credit, you have a loan, the terms of which are not as good as they would have been absent what you learned in the credit report, or in the employment context, you make a hiring decision, you choose not to hire someone based on what you see in a credit report, then you've taken an adverse action in the language of the statute, and you are required to provide notice to the affected person of what's happened. I'll talk a little bit more specifically about employment in a minute because of the recent litigation. All right, this is the sort of final group that is regulated by the Act are consumer reporting agencies themselves. Again, when you think of this, you think about the credit bureaus, but the definition is very expansive. And so to work through the definition, I want to use the example of LinkedIn. Everyone's familiar with LinkedIn. LinkedIn was recently sued in a class action lawsuit, and the theory is it's a Fair Credit Reporting Act claim, theory being that LinkedIn is a consumer reporting agency, like a credit bureau, and hasn't met its obligations as a CRA. On first glance, no one would think of LinkedIn as doing something similar to what Equifax or Experian does. But let's work through the definition. I think you'll see why it's so broad and potentially relevant there. So the statutory definition, I'm going to paraphrase. I've given you the language of the statute on the slide. Basically, it says any person which regularly assembles or evaluates information on consumers for the purpose of furnishing consumer reports to third parties. So take our LinkedIn example. We'll start there. Does LinkedIn regularly assemble or evaluate information on consumers for the purpose of furnishing consumer reports to third parties? They certainly have information about consumers. They are assembling, have a role in assembling or evaluating it and making it available to third parties, that is the public at large. So far, maybe LinkedIn is, and it might depend on what a consumer report is, which is a term that is on also part of the statute. So a consumer report under the statute is also very broadly defined. It's any communication of information that bears on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. And then the second part is used or expected to be used for a permissible purpose under the Act. So you start to see that, initially the definition's talking about credit, and this is a statute about credit, but then anything that bears on a character, general reputation, or personal characteristics are deemed a consumer report. So you start to see the thinking of the plaintiff's counsel that filed the lawsuit and potential exposure if you're linked in. If you are regularly assembling information about a person's character and you are making it available to third parties for something like employment decisions, which LinkedIn does, then you may come under this definition. So that will be an interesting case to watch and see how it turns out, but it highlights how expansive this definition can be, and there are certainly cases in which either a company's operations or particular products that they offer can be governed by the FCRA, and they can be deemed to be a consumer reporting agency. Very broadly, the CRAs, if they fall under this definition, have the most obligations under the Act, and obviously it includes accuracy. It includes privacy, that is they have to take steps to ensure that the credit reports or consumer reports that they send out are only being given to people who can have them and are using them for permissible purposes. And like Furnishers, they have to have mechanisms in place to address disputes when they're reporting inaccurate information. I want to highlight employers because for most people in the room, this may be the biggest touch point for you with the Fair Credit Reporting Act. Many employers, as part of their application process, pull credit reports and get consumer reports about applicants. And there are special provisions that govern that. One, there have to be certain disclosures that are made to applicants about the fact that there's going to be a credit report involved. Second, there has to be a written authorization from the applicant or the prospective employee authorizing that to be happen. And unlike other situations, if someone is going to take an adverse action, before that adverse action can be taken, notice has to be provided to the applicant and an opportunity for the applicant to correct whatever may be an inaccuracy. So I say that because there has been, I highlight in the materials, many class action lawsuits filed based on the disclosure provision. The FCRA says, strangely, that these disclosures have to be on a page by themselves. Can't be combined with other things, can't be combined, for example, with waivers of certain rights. And a number of employers have gotten into a sort of gotcha trap of having these FCRA disclosures arguably not being on a standalone page. And in the materials, you'll see numerous settlements and numerous lawsuits that have been filed and continue to be filed. The principal regulators are two regulators, the Federal Trade Commission and the Consumer Financial Protection Bureau, that have enforcement authority. And there's also very generous remedial provisions for the private bar. For example, in contrast to something like the Fair Debt Collection Practices Act, which imposes a ceiling on the amount of damages that can be awarded to a class, there is no such ceiling on Fair Credit Reporting Act class cases. And this is also a statute that has a statutory damages provision of up to $1,000 per violation. So in a class context, damages can mount very quickly. This will show you that in addition to the private bar, there has been very significant activity by the FTC and the CFPB just in the last 2.5 years. You'll see the civil penalties that have been paid by various entities, most of these being consumer reporting agencies. The two agencies seem to be trying to outdo one another in their enforcement. So this is a topic to pay attention to if you're governed by it. And as I said before, their private remedies are extensive and well utilized. So in conclusion, I appreciate your time and hope that you will give some thought to exposure that you have, a potential exposure under this act, and what it means for your business and compliance.